Hi, everyone. Nice to see you. Welcome to this special edition of Speaker's Corner. We are myself, Marianne Popescu, and Marian Gage are two members of the Advocacy Committee. And one of our goals this year is to bring this episode of Speaker's Corner to you to talk about the art of ILA, and really just helping us to have a good conversation about what it means for mediators and lawyers to work together to ensure that we meet our standards of practice, which is encouraging our clients to get ILA. So that's why we're here. And I'm looking around the room and we all know each other to a large extent. So I'm hoping we can have a nice collaborative conversation about these things. Marian and I certainly don't want to spend an hour just chatting to you. We'd like to interact with you, and we can take your questions and answers as we go along. Or also at the end, you are allowed to unmute yourself to ask questions, and we'll check in with you from time to time. Okay, so I'm just going to give a land acknowledgement. To acknowledge the land I'm standing on today as a traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and it is now home to many diverse First Nations, Inuit, and Métis people. We recognize and deeply appreciate their historic connection to this place. As a settler, I'm grateful for the opportunity to meet here, and we thank all the generations of people who have taken care of this land for thousands of years. So thank you very much for making this space for me for that. And I'm just going to start sharing my screen. Oh, I can't see anything because I don't have my glasses on. Let's do that. Okay, so much better. Oh, excellent. Okay, here we go. So I'm going to start with just a little bit of a slide that we've worked, and I guess I should stop and kind of give a little bit of history. We've worked on this topic for many years in the past, and we've had a presentation with the Winkler Institute, with LawPro and OIFM that has some similar content to this presentation today. However, the conversation we're hoping is sort of inspired and gets us going, thinking about how we can do this better. The first thing I wanted to talk about was getting along in the sandbox, the paint box, the meeting room, wherever we all are, and thinking about how we can build up our community connections with each other, because we need each other. We need each other to be able to work. Mediators who are drafting memorandums or mediation reports need lawyers to help clients to really understand what the implications of the document is that they're looking at. And we want to take like a community-based approach, meaning that we want to know each other. And if I'm sending MOU to Marian, it's like, hey, how do you want to see this MOU written? What are your thoughts for this particular case? And I talk to her beforehand and sort of make that connection. And really, the other thing we're focusing on is taking a client-centered approach, thinking about what the client's needs are and really communicating that as best we can to each other as the team that we're working with. In collaborative, they have an advantage of having a team around the whole family. And in mediation, we sort of have to build that team and work a little bit harder to make sure we gather the people around us that are needed for a good file and a good outcome for the family. And we have to think about the skills that we have as family mediators. We have to think about what our best abilities are, where we may need a little bit of help. For example, if you need capital gains calculation that's very difficult, or something that's beyond your regular work, asking for help from a certified divorce financial analyst or a certified financial divorce specialist, I think CDFA or CFDS, or an accountant or a tax advisor, are things that you can do to strengthen your document so that you can have a good document and have it make sense for the clients from a multiple amount of perspectives. So financial, legal, and mediation. At the heart of it is this family. What do they want to do and how do they want to accomplish it? And then we need to think about the dialogue. I've spoken about that already, between all of us. So picking up the phone or sending an email to say like, hey, I'm Marianne. I'm working on this file with these clients. I understand they're using you for ILA, and I just want to touch base with you to connect so that we know what the expectations are going forward. And then I probably said all these points before, debriefing at the conclusion of the file to potentially identify needs. One of the nice things about debriefing is I've learned a lot from the lawyers that I have had the pleasure of working with. There's a couple who are on here that have shown me a lot about my drafting and my ability to get things right or get things wrong, and listen to their improvements and think about the case law that they're telling me about, and really having this sense of community around the file and community around our work and our expertise, and sharing that knowledge so that we better the client. And then understanding what the next steps are, how changes are going to be managed is something that's really important for the lawyer to understand, like who is redrafting or who is responsible for making amendments to the documents after the ILA stage is done. How's that going to be done? And there really is no the one answer to that. It's just what works out for the clients and you and the professionals involved. And then make relationships with each other to have a more enjoyable time, right? This is your job. We are alone mostly in our own little rooms, and even more so, even post-pandemic, we're not as in person as much as we used to be. And so making this fun and enjoyable and connecting with each other is it's a valuable part, I think, for me in my job. And I love working with all the people I get the pleasure of connecting with through this process. So I'm going to end that version of these couple of slides on getting along and trying to think about relationships, and pass it over to Marianne, and she's going to talk more about sustainable MOU and some legal information.
Okay, thanks. Hi, Marianne, can you hear me okay? Because I know my microphone will go in and out if I don't
Sounds
start in the right.
perfect.
I'll
Yeah.
stay right here then. Okay. So a sustainable MOU. I don't have the slide clicker, do I? No, I can't. Oh, wow. Thank you. But I've got telepathy.
I
So
got you.
thanks. A sustainable MOU. An MOU is a memorandum of understanding. I suspect everybody on this call knows that already, but just in case. And I think it's important, first of all, not just to understand, but to make sure that our clients understand the difference between a memorandum of understanding and a separation agreement. Because keep in mind, clients come to us in a few different ways. Sometimes a lot of my clients will come to me through lawyers, and maybe they're even in the middle of litigation, but the lawyers refer them. And at that point, the lawyers have probably spoken with them a little bit about mediation, and they might have a bit of an idea, but in some cases, maybe not. And then we have clients who come to us who've never met a lawyer in their life. They're coming to mediation because they don't want to ever meet a lawyer, and they're hoping that we'll do everything as mediators. Okay, so explain to the client that you've got a memorandum of understanding, but you sort of have to take it back a little bit. They're coming to you for a separation agreement, but your deliverable as the mediator is, for some clients, the memorandum of understanding. My view is that our deliverable is actually the getting along, the agreement, the fostering understanding. But really, for a lot of lawyers and clients who receive these things, the deliverable is this memorandum of understanding. But this isn't your enforceable separation agreement. And I think you all know that. But I am very aware that our clients don't always know that. So it's important to talk to them briefly, even about the differences between the two. But even so, the memorandum of understanding has to be really clear. It's got to have all of the information and the agreements in it that you would see into a separation agreement, because this is what makes it easy for lawyers. Those of us who are lawyers who have access to the software will often draft this thing in a suspiciously similar to separation agreement form, because we use divorce mate software. So it looks the same, but at the top, it's not a separation agreement. So we're going to call it a memorandum of understanding. Don't forget to do a little search just to make sure that all of this is for the newer people, I suppose, just so that everywhere it refers to this document as a separation agreement, it says this document is a memorandum of understanding. Still provides a roadmap for the parties moving forward. So yes, the goal is to reduce future conflict, and we'll talk about that. It's so everybody understands the agreements that were made. So it's so that it's a little message to the lawyers as well as to the clients. But here's what was agreed to, but here's why. This was mediation. So here are the consensuses that were made. And always here's why, and here's the information that everybody relied on. So often in mediation, just like in collaborative law, these agreements are a little bit different from something that a court would order, or something that a client could expect using a very strict legal model. That's fine, that's part of it. But we have to explain why. So the more this agreement, the more your memorandum of understanding or the provisions in it veer away from a strict legal model, the more time you have to put into these explanations in your memorandum of understanding. I will actually put notes to lawyers or fictional lawyers who might not even be on the file yet in my memorandum of understanding. So for example, if it's an issue with lump sum support, and I know that the lump sum support is lower than what lump sum would look like in the calculations. Not only have I included all of the support mate calculations that I've done, but I'll say, parties agreed on this amount of lump sum support because they couldn't agree whether there was even an eligibility or something. Here's what they didn't agree on with support, but they also didn't agree on the value of the matrimonial home. And so they agreed to use this value for the home and this value for the lump sum support, so that people can make those connections. Because the last thing you want is an agreement coming back to parties, or maybe even the mediator, where one lawyer is saying, that's great, we haven't changed the support calculation, super fine, but there's no way we're using this value for the home. And so it's important for everybody to understand. Saves legal fees too. It saves time going forward if the lawyer understands everything all at once and that concessions were made. So if you get an agreement from me when I've got my mediator hat on, you'll see a lot of notes in italics. That is like, those notes are to the lawyer, or even a future decision maker reading that agreement so that they understand why those agreements were made. They probably won't make it into the separation agreement. Sometimes they do, sometimes they don't. This is a memorandum of understanding, so it's got more explanation. I should probably look at this slide more. Okay. Oh, okay, next slide. No, this is good. Next one's good with the windmills. Okay, so 4 key components of a sustainable memorandum of understanding. Progress notes, you're going to back it up with your progress notes too, as a mediator. So those are 2 separate things. You'll have your progress notes that say, for me, they say, here's what happened in the mediation, but not issue by issue. And there's no, they said, it's more like, here are the agreements that were reached, and here are the reasons why those agreements were reached. Here is the information that everybody had so that they could reach those agreements. Here's the disclosure that was made. Here's the disclosure that's yet to be made, because sometimes the notes will say this agreement was reached subject to disclosure to back it up. Sometimes we're waiting for a tax return or pension valuation or something. Here are the calculations, etc. But in the progress notes, it's just, oh, and then I'll also say, here are the to be considerates. Here are the things that people need to be considered. So every mediation, whether there are agreements or not, usually gets these progress notes. Those would go along with the memorandum of understanding so that you can sort of read it and understand if you refer back to the progress notes, what's going on. Often in my very last mediation, when all of the agreements are settled, I'll ask the people who've now spent quite a bit of money on it in a lot of cases, do you want me to do final progress notes, or should we just reflect that in the memo of understanding, in which case you get a memo that has more italics, but not a separate set of progress notes. You do you. Financial documents disclosed during the mediation. So don't wait for the lawyers to ask for financial disclosure. This is a simple thing that you can do to help the process go more smoothly, makes things less expensive for your clients, and it sets expectations as well. So as mediators, we know what clients need to know to make decisions, and we know that they need to prove it. And we know that when they get in front of a lawyer, they're going to be asked if there was proof, because the lawyer is going to want to make sure that those are the correct numbers. So work with your clients to do financial disclosure in the beginning and get all of those documents. You can help them organize it. If you have a clerk that does it, they can do it for less money. But it's really helpful to make sure that clients, A, know what they need to provide, and then provide it. And if there's anything outstanding, that they understand what that is and that it's going to be asked for. And when you're not sure, somebody doesn't want to provide something like long list of bank records, etc. If you know the issues, you might be able to say as a mediator, okay, if you guys are agreeing not to look that deeply into something, just know that when this gets to your lawyers and you go for independent legal advice, the lawyers are going to have questions about that too. And that might end up costing you more money than going to the bank and getting that document. Just saying. Calculations relied on by the part. I'm doing a terrible job actually looking at the slides. Sufficient detail. Yes, the things I've said. Slides great. I'll do the next slide, please.
Hang on, I'm just trying to go to the next one. Here we go.
That's fine. It gives me a chance to read it. So
Yeah,
what is a durable agreement? So a durable agreement stands the test of time. Look at the slide now. So it's going to be respected by the courts. So if it's challenged, the courts will be more likely to uphold it. It's going to be more enforceable. So what that means is it's going to have the key components of a domestic contract in it. You're going to have the financial disclosure. People are going to understand their contract, and there will be proof, for example, a certificate of independent legal advice signed by a lawyer, that they did understand it, that there was no duress. It has to make sense. So there should only be one way to interpret it. That's our job, is to make it something that's clear. Anticipates future needs of the family so that there's structure, so there's no conflict in the future, integrity in the process. So again, as mediators, we learn a lot, and we have rules around making sure that there's no power imbalance, or that any power imbalance is corrected as much as we possibly can, that people are coming to these agreements at their own volition, that there's no duress. And again, with the financial disclosure, and keep in mind, when people come to you and they're saying to you, as they often will, oh, I know, like, we trust each other. We would never want to revisit this again. Okay, fine, that's great. That's one piece of it, but it's not necessarily just them. And this is what I explain to clients when we're talking about the steps we need to take to make an agreement reliable. Sometimes it's not the other person. Sometimes it's not the ex. Sometimes it's a bankruptcy trustee, or somebody who has power of attorney in the future. Somebody who has a fiduciary duty that is different from the agreements that they might have made. So you want to make sure that this agreement can be upheld when some third party comes in and their one job is to make sure that the agreement works, or make sure that the situation works best for their person, for their client, or for creditors if it's a trustee. So just something to keep in mind. So a durable agreement, yeah, I think I'm talking fast. I think I covered it. Beautiful slide. I'll move on to the next slide.
Yeah.
Drafting.
Do you want to take a little break and ask if there's questions? Because there's a huge amount of people here. I didn't expect that many, but I've scrolled through, and I think it's all friends and people who know each other. So I just wondered if we give a chance to see if anyone wants to unmute and ask a question. Feel free to do that right now, I think. Is that okay, Marian?
That's great. Just know that we're talking about ILA and what it is and how we talk to clients about it in the next few
Yeah.
slides.
Yeah.
So,
And drafting and information, all that good stuff. But any questions based on what we've kind of shared already? Trying to use Elizabeth's moment of silence. I can't do it. Let's keep going. If you have questions, you can also put them in the chat and I'll have a look. Okay. Drafting for family mediators, then I'll go to the next slide.
okay, so drafting mediation reports, I just call them memorandums of understanding. Keep it clear and appropriate for the needs of the family. So yes, you're writing for both the lawyers who will be reviewing it, future decision makers potentially, and for the clients, but make sure that it's something that the clients can read, because at the end of the day, they're the ones that will have to pull it out of the drawer if they have a dispute resolution issue and understand it. Explain again where families agreed to compromise and why. Again, for me, it's those italics. For you, it might be something else, whatever works. Include legal model and settlement model net family property statements if they've deviated from the legal model. I think this is really important because, like in collaborative law and in mediation, I usually tell people that that equalization calculation, for example, is a starting point, but it's a really important point. So step one would be gathering the financial disclosure. Step two would be calculating it when it's a property issue, what that equalization payment looks like. And then there's a step three when we're in this decision-making mode and we're in a different process where people can make decisions based on knowing that. So if you're going to do a few different scenarios or different net family property calculations, include all of them. So whoever's reading it will understand at least what the bookends were. And a net family property statement too, just as an aside, like include the areas where it wasn't necessarily agreed, but things have been settled. So for example, if there are different values for the house and then they settled on the value, they put a note in the net family property statement. More information is better than less. Same for if you've got something like date of marriage debts or date of marriage assets, and nobody agrees on the amount, and there isn't necessarily proof, talk about that. Write a comment about that in the net family property statement and show people the two different net family property statements, like what was agreed on, and then what it would look like using a strict legal application where, for example, you're not including any of those, so they can see the difference. It can help the clients too, because sometimes the thing that they're fighting about really is the principal, and it's not the dollar value, and the dollar value isn't worth fighting about. And if you can show them the different scenarios, sometimes that can be very helpful. Sometimes not. Sometimes it's a huge variance, and that's a different story. And support calculations, and then the facts relied on to come up with incomes. So, and parenting relationships and things like that. So for example, in the support mate calculations, there's room for comments too. And I really like it as a lawyer when I get a mediation report where I can see all of the different scenarios that people relied on. There's a mediator here who will do lots of different scenarios and like rename them 1, 2, 3, 4, and explain it. It's really, really helpful because then you know exactly what people were thinking when they came up with that. One of the areas where I really like to see it is on spousal support, where a lump sum is being calculated, but you've got children who are about to age out of child support, or might, or will probably age out of child support. It's great to see the different scenarios. So you could see like, what would the lump sum be for the next 2 years? What might it be for the next 3, next 4? And then again, as mediator, that's an area where you would write in your memo of understanding, maybe in italics or somewhere. Everybody understood, we talked about how these were hypotheticals, and you don't always know. You don't have a crystal ball, so you don't always know, but these are the assumptions that people relied on. So yeah. The communication package. I love the communication package. And do these ever vary? You might get a 0 communication package, like you might just not get one as a lawyer providing independent legal advice. Or on the other side of it, you might get a link to a beautiful folder with a lot of documents in it that, for example, in my perfect world, and again, everybody likes things to be set out a little differently, there's a secure link. There is a folder called Memorandum of Understanding. It has the draft Memorandum of Understanding. There's a folder that says financial disclosure. You can guess what's in that. It's the financial disclosure. There's a folder that says support calculations, and you see all the different support calculations. There's a net family property statement folder, and there's a folder that says progress notes. So, and sometimes even a miscellaneous folder that has a whole bunch of disclosure that clients provided that you never cared about and you didn't want to see, and everybody understands that's miscellaneous. So that's kind of like, for me, that's the gold standard. I like to get that because, well, and I like to use it too, because I'll give it to clients as a mediator in the beginning, so they can start uploading. And you know, as mediators, we say to our clients, don't email me a bunch of documents without copying the other person, and it doesn't matter because they're going to do it anyway. If everybody has the same secured link, then in real time, we all get the documents at the same time, and you know for sure that the other person had access to them. And then you can give that link to lawyers who are involved too. And it works really well, in my view. So, and there's even, click on this link here and you'll see that's not a secured link. That's just a link to some standards that are worth looking at. And there are some precedents in a video that you can watch there. What am I missing?
You're not missing anything. I just wanted to add that, so the advocacy committee, we're talking about, like, you know, the cost of divorce made and how the cost has gone up, and it's been a little bit prohibitive for some people to purchase the monthly amount. So we've been looking at alternatives and thinking about all sorts of things, from writing our own software to, you know, really amazing ideas from the advocacy committee. And I looked into ADR Notable, which is a company that does have Canadian servers and has Canadian roots. And they're actually in the midst of sort of figuring out if they can give away a member rate. So it has a lot of organization in terms of financial data collection. I know a lot of people use Dropbox right now, and that it's a format that a lot of people use. So, and I know there's other ways to collect data, but ADR Notable is one that we're going to come to you with information about soon. So hopefully,
don't shoot me. I use Leap.
Yeah. Well, I think Divorce Night Leap, like it's a great program, and anyway, it's just the price has become an issue for a number of you have contacted us to say, hey, can you do anything? And just it's good to have alternatives, right, for people and see if it works. We'll see what happens. Still on with you, Marianne. That's enlightening clients to ILA in a happy duck sort of way.
I like the ducks. I really
I
like
like,
these slides, Marianne. They're beautiful. I'm
I,
gonna read them more.
yeah, pretty, pretty.
So this is particularly important when you have people come to you as a mediator who haven't been working with lawyers. And they come to you because they hate lawyers, and so they're very happy to be with a mediator. And it's important for them to understand that there are going to be lawyers. And for OAFM, the standard is that we are recommending and asking and begging people to get independent legal advice on their agreements. And I know that the way different mediators approach the issue of independent legal advice, from on one end, like not even sending the draft agreement to clients, only sending it to lawyers, to just sending it to clients and say, yeah, lawyers are a thing and you might work with them. I think it's important to know the OAFM standard here is that you get your clients to get independent legal advice, and you're explaining to them that that's how it makes the agreement sustainable. That's how you protect yourself. It's for you. It's not free, but if you have done your job in the mediation, it also doesn't have to be super expensive. Like Marianne was talking about the relationships we have. It's so helpful if you're able to tell clients who they can go to for independent legal advice. Don't quote the lawyer's fees, but you have a pretty good idea who's going to charge $5,000 and who's going to not charge $5,000. Explain to clients early on too. This is me with my lawyer hat on, I suppose. I shouldn't be doing this, but I am. Explain to them that it's not the cost of a free consultation or a cheap consultation. It takes more, because independent legal advice involves client meeting with the lawyer learning their case and their facts and their issues, the lawyer looking at the agreement, and giving them actual legal advice. So providing information, options, the cost benefit analysis, a lot of that stuff is done in mediation, but then on top of it, talking to them about the law and reviewing and signing the agreement, reviewing the financial disclosure too. And then also a reporting letter. And that all takes time and money, and more than a half hour, definitely, or an hour-long consultation. So I think it's important that clients understand that. It's not a free piece, but I think it's also important that maybe they understand what it costs to go to a lawyer if you're not doing a mediated agreement, and if you're going for more than ILA, because that's always a lot more. The lawyer's doing more work, and you're each paying your lawyer to do that. So when should ILA be arranged? All of these answers are true. Like, I love it when clients have come to me after having, most of the time, after having a legal consultation, because then they have some idea of what the baseline is, what the law is, and how it applies to their situation. Sometimes there's a little bit of overkill, and you have to bring them back a little bit from their legal positions. During mediation, I have been known to say often, you probably want to get some legal advice, and why don't we kind of stop the mediation now, or put a pause on that issue, put a pin in it. Both of you go get some legal advice, and then we can come and talk about that later. And in the confirming notes, it'll actually say, like, issues parties have been asked to talk to their lawyers about, and then come back and discuss. And sometimes that's because legitimately there are some gray areas that really require legal advice so that people can weigh their options. And I don't want to overstep my job as a mediator by giving legal advice. Sometimes that's like Marian speak for one of you is being really unreasonable and you have no basis in law for doing this. And, I can't really tell you that much about this, but why don't you go see a lawyer and have them tell you too? So there's a bit of that. And then at the end of the mediation, obviously, to give the advice and review all of the documents. So some lawyers will do packages when they know they'll do like an ILA package where they'll say to the client, here's what I'm giving you, but you're going to be doing most of your work in mediation. Sometimes not. I will say too, there's the legal advice, but it's also important if you've got two lawyers who are working with the clients, and especially if you know them, but even if you don't, ask the clients during the mediation if it becomes necessary. If you could have a short conference call with the lawyers, it can be really helpful to understand what the lawyers are telling their clients, and to understand for your mediation where that disconnect is, because sometimes it's not the client at all, or sometimes it's totally the client. really helpful to connect with the lawyers when there's a difficult issue. And I love it when people do that. So also before mediation, if clients will allow it, I like if clients came through lawyers, I think a lot of you guys know this. I like to have a conference call with the lawyers just to see where everybody's coming from. So, and there are some lawyers that insist on providing briefs no matter what. This is a little bit off topic, but I do always say, like, if the briefs are going to inflame things and you know if they are, then just don't do it. That's okay. Like, I'll get the information. If the briefs are going to be helpful, or if you're going to do a joint brief, because that happens sometimes, that's great. Okay, that's that. Nice slide. What is the purpose of ILA? It is to make sure that the person who is signing the agreement understands it fully, understands the nature and consequences of their agreement, understands all of the terrible things that could happen to them if they do or don't agree to certain things, is aware of any legal, financial responsibilities they're committing to, knows about the rights that they might be conceding, knows about the legal rights that they might be conceding, and understands. Think of it sometimes as though somebody is going to talk about, they're going to go to the bar and talk about their agreement with their friend who also got divorced. And let's say their friend says, oh my God, that was so good. Like, I didn't have to, my lawyer told me I don't have to do that. And I can't believe you did that. And you got talked into that. Well, that's something lawyers fear all the time. We're always worried about law society complaints. So they are going to get the good and bad and the ugly so that they can make an informed decision. So it's not a lawyer tearing apart the agreement so much as helping the client make an informed decision so that the agreement is reliable, so that it doesn't get set aside in the future, but also so that there's no buyer's remorse if they find out information through broken telephone later. Yeah.
This is your last slide.
Oh, okay, good. It's a nice slide. What else does a client need to know? The Family Law Act, so equalization process, child support guidelines, and spousal support guidelines. Remember, as mediators, we can give legal information, we just can't give advice. So we have a duty to tell them about how this stuff works. We can't just say, I don't know, talk to your lawyer about everything. The legislative model, rights and responsibilities, the pros and cons of diverting from the legal model when possible, so that they can choose a result that works for them. And then keep in mind the lawyers with legal advice, of course, the lawyers are going to expand on that a lot with the clients. So
nice. Thank you, Marianne. Well, before I get started, I'm going to talk about a few pieces about communication. Is there any questions? There was a question in the chat about the slides. If you want a copy of these beautiful slides, you can email me and I'll send them along to you, no problem. Are there any questions so far? Are you reflecting on anything in your own practices? How do you feel about the process of encouraging clients to get ILA?
I mean, it's usually written in our agreement anyway that they should get independent legal advice, but I always remind them that it's to their benefit to do so.
That's right. Yeah. So, and then thanks, Claudette. That's right. The ILA does not prevent the SA to be put aside. The ILA does not. Okay. So I think any agreement can be put aside, right? I think it's no agreement is 100% durable. I think we're talking about increasing durability, and ILA, does not guarantee that an agreement will not be set aside. Marianne, would you like to comment on that comment?
oh yeah, that's absolutely true. There are agreements that are drafted by lawyers without mediators being involved. So it's just been ILA from beginning to end that have been set aside. So absolutely, that's a thing that can happen. But what we're doing is we're trying to make the agreement as reliable as possible. So it is less likely to be set aside if people can show that they understood the nature and consequences of the decisions they made in that agreement. The best way to do that is to say, well, I got legal advice. I talked to a lawyer about it, and that lawyer stamped it for me. The lawyer signed the independent legal advice, and the lawyer's liability is a different issue. We're not talking about that here. Like, we don't just rubber stamp these things, obviously, but it definitely, it helps. It makes an agreement more durable for sure.
Okay, excellent. Thank you. And another question, and then Elise, I'll call on you in 1 second. What if the client wants to sign the MOU? don't let it happen in front of you. I guess that would
Oh,
be the,
yeah, so don't
yeah,
witness that.
don't do anything like that. Yeah, yeah, yeah,
I have
run
a
away.
question or a comment.
Yes. So I'm gonna go, Diane, I'm gonna go to Elise first, and then I'll come right back to you. If you can put your
Yeah,
hand
I
up,
just
then
can't
I'll.
find the raise hand function.
Oh,
So
I'm
I
gonna remember,
apologize.
Diane. I'm gonna remember. Elise or Alyssa?
Hi.
Hi.
So the issue I've been having recently is that it's been hard for clients to find someone who will give them just legal advice on the memorandum, right? Or a discrete legal issue. So I have some clients right now who I said, look, you're sort of at this space where they're talking about an unequal division. And I said, at this point, I think you should go and get some independent legal advice because there's a whole bunch of factors going on. I wrote them a lengthy letter to go to their lawyers explaining everything that had been discussed and where the points were, where they needed to get some legal advice, and the factors that were under consideration, etc. And they're just saying like it's really hard to find someone to just review that. And I understand that the lawyers want to see all of the disclosure. They want to see everything up front. And it's a much lengthier sort of review than just the discrete issue that they're talking about. And they'll probably go back to them to review the final, like to do the final agreement. But a lot of what they're getting back is like, well, we don't give advice unless we've drafted the agreement, or, you don't have an agreement for us to look at. So we can't help you. So I'm just wondering, like,
Yeah.
just seems to be a gap in service, or is it just a challenge?
I think that, yeah, I mean, I think part of the reason we're doing this is to try to help you to communicate and get along well with your in the community and find people who will work with your clients. The Law Society and another project called wait for it, the Family Law Limited Scope Services Project, the FLISP, and the Law Society both launched access to unbundled legal services. So access to a group of lawyers who put their hands up to say, I'm available for unbundled legal services. So both of those resources are available. The Law Society has, I haven't checked, to be honest, in the last couple of years, probably since we did the project, to see how that took off. Marianne, do you know anything about, like, have you got any feedback from your lawyer colleagues about the FLISP or the Law Society's unbundled legal services listing?
Yeah, I know. So we applied to go on the listing, and it takes a little while because I think it's run by students. So it takes a little while even once you've done the application to get on there. But we do have a lot of requests for unbundled legal services just because of like the financial climate right now. That's what people are looking for a lot. I also find that, to your question, Elise, if you recommend lawyers or go with lawyers who are also mediators, they tend to understand this stuff a little bit more too, as opposed to if clients go to litigators who don't mediate at all, because they understand how the mediation process works, and that might be a little more helpful. But the unbundled project, so far so good, I think. Like we're noticing a lot of uptake. That's all. That's anecdotal, I know, but
Thanks, that's helpful.
Yeah, there's a couple of notes. One, a service that involves collaborative mediation, where the mediator is letting me know that they do mediation, and also in the package cost, the legal services are included in that mediator's fees. So the ILA is part of the package, and she works with a group of lawyers who do the ILA. That's similar at Common Sense Divorce, where I do mediation. Every file has lawyer plus a little extra fun legal review before that mediation agreement even goes to lawyers for ILA, which is fantastic. And I'm not going to forget Diane. So Diane,
Sorry,
you had
it
a
took
question.
me forever to find the raised hand. I thought.
That's okay. It's okay.
Just with
Yeah.
regard to lawyers, I will generally look for lawyers, as Marian said, who's also mediators, because they understand that sometimes people are being creative. So that's something. And the other thing that you can look at is if you look at any of the practice groups that actually practice collaborative law, and that's a little bit different from what collaborative mediation is. And I think that we could have a whole meeting just on that. because the confusion about what is collaborative practice and what is mediation. And I don't think collaborative mediation is the same. But having said that, I that's what I would look for. I'd either look, like I often refer to other collaborative lawyers or lawyers who are mediators. But I guess what I was going to say with regard to when I'm meeting with clients and kind of going, when they're being creative, kind of when you've done your NFP, you've kind of done some calculations and things, and they're going outside the box, that's when I really check in with the clients. You know, tell me what you understand about this, because I'll say, you're going to have to explain this to your lawyer when you get ILA. And I want to check in with you to make sure that you can articulate in front of your spouse or your partner what it is that you understand about what you're doing before they go, because there's, you know, it's not that lawyers are putting the kibosh, but it can really muddy the waters when somebody comes back and they say, oh, well, I don't really know, my lawyer told me not to do that. And it's kind of, you know, so, and of course, when you're getting in those conversations where people are going wildly outside of the, what I call the ballpark of reasonableness, is I'll say, you know, before the next meeting, I'd like you both to check in with your lawyers. And if you need referrals, you know, again, look at a collaborative website, look at that. And I guess my bias is that if some of the lawyers who are collaborative are also mediators, and they're not just strictly litigation lawyers will look at consensual dispute resolution with a different light and a different lens than other lawyers. So I sometimes think that that ability for people who really understand ADR, so find that roster of lawyers who have those skills when you want to refer clients out for ILA. That would just be my comment.
Yeah, it's good. And I think those are excellent bits of advice. In the chat, there's a couple of things like looking at the OIFM site to see lawyers who are mediators who are also lawyers, so that you have like a camaraderie between each other. Hey, I know you're an OIFM member, you're a mediator. Are you, you know, can we talk about ILA and what your services are like, and trying to make those connections. And then another comment about, like, the longer you're sort of in this business and the more, even coming here today to this event and seeing each other's names, and if you see someone who's a lawyer that you might want to work with, an ILA or a mediator that you know does a lot of files that you wouldn't mind doing ILA for them, like, reach out to each other. You're all listed on the website. If you need an introduction, helping hand, I can do that for you, so that you can make these good connections and be part of the OIFM community, and trying to create this community of practice that we work together. Daniel has a question.
Yeah, hi.
Hi.
Yeah, I have a question, well, for you and Mariana. Is what is the value of the waiver? Like, I have cases that I feel very unfair and I feel very bad, and I promote independent legal advice, and they don't care. So obviously in my old package, I have waivers. What is the real value of the waiver when something is very unfair, and they can go 2 years later to the judge and say, this is very unfair? Well, yeah, we know, but they sign the waiver. Does it have any real legal value in the eyes of the judge?
I'm going to leave that one to Marian to answer. There is a case that's interesting about a couple of clients who made an agreement fairly recently that had got some attention. I can't remember the name of the case right now, but they did their own agreement without ILA, and the judge enforced it or upheld the agreement. Marian, what do you think the value of clients signing a waiver to say, hey, I know I should get legal advice, I'm advised to, but I'm not following that advice?
Yeah, I think don't promote it as a mediator, but it's an option if you've got parties who, like, for example, if you've got somebody who really needs to move on with their lives and the other person won't get ILA, what are their options? Is it just do nothing, or they have to take the person to court, or this agreement is signed? Now, again, as mediators, we're looking to help them get a balanced agreement. There are some things we can control within the process to make sure that the discussions are balanced, that that there's no duress, etc. But there is case law now. It's like the pendulum has started to swing in another way, where courts are now saying, okay, you didn't get independent legal advice, but you could have or should have understood the nature and consequences of the agreement, and you had the option to do it, and parties have the freedom to come to their own decisions. We're reading that in a few of the cases now too. And for that reason, it's not necessarily going to be set aside just because there's no legal advice. Just like we were saying, it's not necessarily going to be upheld, even if there is legal advice. Doesn't mean it's going to be set aside if there's not. It's just another layer of protection. I definitely like to have lawyers looking at these agreements for sure. But it's an option. Now, as mediators, we don't want to be signing that with them, right? Like, in fact, I have a case where I just said, you can find a waiver of independent legal advice. Like, here's an example, but I didn't attach it to the agreement. I attached certificates of independent legal advice to the agreement. And then when they emailed me again and asked for that, I gave it to them. I don't know what that did. He didn't get independent legal advice. Fine, whatever. They had their agreement.
Nice. Thanks, Marian. Diane found her hands up button, and then Vicky.
I just wanted to comment on it because I will say that as a mediator, I also think that we have an obligation. If we think someone's giving away the kitchen sink, like it's wildly outside of the parameters of reasonableness, and they're refusing to get independent legal advice, we may have an obligation to simply withdraw and say that we don't feel that the mediation process is serving the client or whatever, and just simply withdraw from the mediation. Because if it's going wildly out of control, or people are, saying, and they don't want to speak lawyers, I'm worried about coercive control. I'm worried about what's going on behind the scenes and what's happening there. So, but on the other hand, I think if it's a really kind of a simple, straightforward, the legal model's pretty much been followed. And I never witness a mediation report. I send it out to them and say, it is now up to you to get independent legal advice, if you don't get independent legal advice, to sign it in the presence of a witness, and I give them the things. But I mean, if somebody's refusing to get independent legal advice and they've just given up everything, or it's wildly unfair, I simply would withdraw from the mediation. So I kind of think there's a bit of a balance that we as mediators are responsible for, because I would never want anything to go out into the world that was wildly unfair, and 3 or 4 years down the road, somebody looks back and says, this was garbage.
Yeah, but on
That's
the other
right.
hand, Diane, you have the concept of self-determination, right?
That's right.
There's self-determination, but I guess at some point you can say, okay, then self-determine. Then go out, be free, go out into the world and self-determine. But I'm not, because I'm all about creative, like think outside the box, think outside the legal model. I'm all about that. I've done many mediations that have been that. But if they're wildly, I just tell them it has to be within the ballpark of reasonableness is kind of my standard.
Yeah.
Okay.
And remember, we also have to screen, right? We're doing screening for power imbalances, like with or without that independent legal advice at the end. We as mediators have obligations. We as accredited mediators have obligations and standards that we have to follow to make sure that that process, whatever happens at the end, that process was balanced, that process allowed people to make these decisions in a way that is fair and that made sense to both of them. So
that's right. And I learned from my friend who has a question after Vicky that, like, why do the clients need you? Like, maybe, and right in our standards of practice, it says, Diane, that the agreement being reached is unreasonable or unconscionable, that the mediator has the right to withdraw. So you're backed up by that. And that saved me a lot of times, Neeraj, that advice you gave me, because it's like, okay, so you've got an agreement, so go ahead and write it. One of you is a lawyer, go right ahead. If you don't want to do financial disclosure or, all these other bits and pieces. So that's a really good piece of advice. Vicky, then Neeraj.
Yeah, I was just going to reinforce, if it's unconscionable, as mediators, we also have an obligation to do no harm. And so I think it's important that be our guiding principle as well. And even though we screen for power imbalances, there may be other things that aren't being considered or haven't been discussed as to why they're quickly wanting to get things resolved independently. And so if it isn't, like, if they wanted to waive child support, for example, right, that's not their right to do that. That's the right of the child, right? So just to keep that in mind as well. We do have rights as mediators that if it's unconscionable, then we shouldn't be proceeding.
That's right. Excellent. Thanks, Vicky. Neeraj?
Yeah, hi, everybody. I wanted to just say that when I act as a mediator, it's my own personal rule that if I know that parties are going, or that they're interested in waiving ILA, even though I've been very insistent that not insistent, but encouraging them that they should get it, then I will still draft my MOU with all of the clauses in there that assumes that they're going to get ILA. So I put in the certificates of independent legal advice, and I've made that assumption. And I've said to them, listen, you can take that out if you want, right? Because I'm giving it to them in a Word document. But I don't want to ever be seen as the person who encouraged them to waive ILA. So that's what I would suggest you might think of doing. You don't want to ever give anyone the impression that you helped your clients to waive ILA. So, but you can always tell them, listen, you can take it out if you want.
Mm-hmm. There's that self-service, self-determination.
Absolutely.
Yeah. Daniel.
Okay, I think we need to keep in mind too, and we can't forget that a lot of the issues that are driving this are emotional, and you know, there's a lot of numbers and people throw numbers around, and people get stuck. But a lot of the issues are there's emotional healing, there's anger, frustration, resentment, all kinds of things going on in the background, and sometimes that is accelerates maybe people's desire to get out, move on, get it behind them. And so, you know, there is some self-determination there where you can say, well, if somebody wants to an imbalanced agreement, within reason, I'm not suggesting that if it's wildly imbalanced or if there's coercion, but some people do want to move on and they're willing to cut corners. And I think that's really where maybe the gray area is in the self-determination, is to allow people that and respect that, the fact that they're going through something that we're not. Some of us may have been through it, of course, but they're going through it, and a lot of the issues are not necessarily legal. They're not necessarily financial. They're driven by other things. So just to keep that in mind.
Thanks, Daniel. I think my first slide of my next part of the presentation is the red convertible test, which is does anyone know the red convertible test? I have a fancy slide. I'll show you my fancy slide just because it's so pretty. So the red convertible test is the consumer cool-off, the red convertible test. So it's where, you know, you have exactly what you're talking about, Daniel. A client is like, you know what, I don't want the house. I had a file where the dad knew his parents were passing away. They actually had both scheduled made. He knew the date they were passing away. He knew he was getting a house, and he wanted to give the house to his partner, who they had 3 children, 2 with special needs, and he wanted to do that. And so you work through with them the red convertible test. The red convertible test is where you imagine, you ask your clients to imagine, like, you know, if your partner repartnered and was living in the matrimonial home with this new person, and they were driving around in a convertible and looked super happy, would you still feel satisfied with making that decision? And the clients have a moment to think about the future and think about if they'd still be satisfied with that outcome. And so that's the test I use in mediation. It adds a little bit of reflection and time to think about their future selves. So thanks for adding that, Daniel. I think it's very important to give people time to do that. Anyone else with questions here? Okay, do I have time to do the rest of my, oh, I have time. Okay, I'm just doing the rest of my slides so that we feel like we've got to the end. And if you are wanting the slides, can you please send me an email rather than the chat, because I won't have time to write all that down and do a good job for you here. So I'm just going to ask you to email me at director@OAFM. Maybe Judith, you could pop my email in the chat. However, it might not come to everyone. Anyway, I'll put it in afterwards. Communication. So are there any language barriers? Are there any cultural barriers? Are the clients acting freely, or are they under duress? Is there any pressure for the clients to mediate instantly? I have a couple right now who the parent, the one spouse, is facing going into rehab imminently. And so there was a real rush to think about, like, are they selling the house? Are they transferring the house? He didn't lose his job, but he's on long-term disability, and he qualified for a mortgage to buy her out, but he was unable to satisfy the bank that he was currently employed, because his employer won't give him that letter until he's finished rehab and comes back. well, rehab is 90 days, and then the mortgage value or offer expired, and they had to think of other things. But this was a case where I was very concerned about the pressure to mediate and resolve because of the instant pressure of rehab, and then the financial pressure of they can't afford this house. It's, you know, it's really become untenable for them to live in this situation. So you have to think about weighing those factors and thinking about how to communicate these things to the other professionals that are involved in the file. And then thinking about, like, I love the ILA I get now, which is like, the lawyers will write back. It is clear from speaking with the client that they've read the agreement and reviewed the agreement with the mediator several times. And I'm like, oh, that's great. So it means that you've done a good job of actually looking at the agreement together and sharing screen and having a look and saying, like, look, this is what this sort of means. And, you know, these are sort of some legal areas that you might want to ask your lawyer about. And that piece of them actually understanding before they leave your office is really a reassurance, I think, to the lawyer who catches them on the other end, who's like, okay, they got it. They understand what it is that they're doing. And then follow-up is a big thing for like the flow of, like, how do you transfer? How does the pension get divided? You know, these pieces are a little bit more difficult to communicate, but you really should be talking to the clients about the next steps for directions, like when will the equalization be paid? How will it be paid? Within however many days of what happening will it be paid? So these are very important facts that actually, when I was working on the other presentation with Law Pro, they were very big on. So if you're a lawyer mediator, I think this is even of more importance to think about who's responsible for all of the actions that are going to be taken that are written into your agreement, those actionable items. So being clear about that is important. And then thinking about inconsistencies in provisions. So, you know, you've written one thing one way somewhere, and then it says something different in another space. I think having someone edit your work, so having the lawyers who are both looking at drafting, it's very important for them to sort of look at it, and everybody to sort of be looking out for these inconsistencies. And then are the things that you've helped the clients come to agree to, are they not only enforceable, but are they doable, right? Is it, you know, recently I had one where dad was going to buy out a house, but then dad's income was extremely low. He was a corporate electrician, and he declared very, very, very little income, and he wouldn't qualify for the mortgage. He thought his corporation could qualify for him for the mortgage, and he was mistaken. And then we had to completely redo the agreement where we flopped the property, like a rental property, to to the mom in this case. So making sure that, like, what they say they can do, like qualify for a mortgage. Especially now, I think mortgage qualifications are really tripping up a lot of families with the getting to the end, because those mortgage qualifications are so difficult. Back to the drawing board. So this is where I think that we are very we're not as much in step with each other when we're thinking about, like, after you've drafted something, like, how do they finally get to a separation agreement? So they're going through lawyers, and even where I work, that part wasn't as clear until more recently, where we sort of have fine-tuned the process, but it takes a lot of thought to think about between yourself and the other professionals, like, you know, how many times, for example, have you gotten a letter back from a lawyer that just thinking that you're a lawyer, that you sent this draft, and then they're asking you to make changes and comment on things where it's not actually your role, it's between the parties, two lawyers, to try to kind of sort things out. But you can step in and clarify what your role is and clarify how you can help, and how the clients want you to help, I think, is one of the most important factors too. Like, how do you want me to help you get to the finish line? I think that's very important. So back to the family-centered approach and the client-centered approach, I think that we started with, thinking about, like, at the end of the day, we're trying to help families, you know, live with more, like, you know, ease and peace, and try to get on with their lives to the next chapter. And so we really have to go back to the basics and think about what is it that we're writing, who are we writing it for, and how do we want to, you know, wrap it up for them. So there you go. We got through all the pretty slides. Any follow-up questions? Gail.
One thing I've added to my memorandum of understanding, so I'm from the get-go, they have to do disclosure and they have to have lawyers on the file. Otherwise, then I'm not the right professional for them and they might as well not seek working with me from the outset. So it's very clear at the beginning in my MOUs indicate they won't sign it. They will get independent legal advice. I already have their lawyers' names within the NFP, so all that piece is in there. And then I send the MOU to the lawyers, and in the MOU it says lawyer A will draft and lawyer B will review. So it's very clear on that. And I kind of time frame it out that I think, they should have something back to the clients 2 weeks, whatever I think might be reasonable. And I'll circle back to the clients. Have you had a meeting with your lawyer? Have you seen anything? And if not, I'll circle back to the lawyers. Where are you on this? And in my MOU, it directs the lawyers to send me an electronic signed copy. Then I know it's done. That goes in my file. So I know that if the clients call me after the fact, I have, well, here's what you signed. And generally it is exactly what the MOU looks like, because I send a Word document in addition to the PDF that's been approved by the clients. And then I do my post-separation checklist. You got to fill out these forms, go and get a will, go and get this done, go and get that done. So like it steps it through, and I've got that those closing steps that just trigger how I'm going to then close off the file. And I think that that's been very helpful.
That's very, very, very full circle. I think that I applaud you for having that. I think it's good to have that set of like wraparound. And I think for a lot of us, you know, working on fine tuning that wraparound is something that that we do, that we've heard about people struggling with for sure. So that's good, Gail. Speaking of like sort of resources and that sort of thing, someone was asking in the chat for a waiver, like an example of a waiver. I don't have one, so I maybe you could, so if anyone has one, they could pop it in the chat. But I think as Marian said, you know, we don't want to be seen as the encouragers of waiving ILA. So maybe it's good that we don't have one readily available at our fingertips. Yeah, so thanks. This has been great. I really enjoy this conversation. I think that we can all learn from each other. I think that like one of the main reasons that we are trying to do these ILA presentations is to really demystify and to try to work better with each other and to help build relationships. And I think it is about relationships in our community and building trust and getting to know each other. And like I said, just coming to these events is helping us to connect. I can't leave without giving a plug to Family Peacemakers. There's about 20 tickets available still. If you want to come, that's May 3rd and 4th. And the hotel rooms are a treat at $189. And if you act now, I will send you 2 smiley faces. I don't know what else to say, but it's going to be a good event. We are going to be in person with each other. It's with our friends at Collaborative, so OACP, lots of collaborative people on the call today. So I hope that I see all of you there in person. There's going to be a dinner dance. And I've just finished the menu selection. It looks pretty good. Lots of vegan and vegetarian options too. So there you go.
Can you tell us what's on the menu?
Pardon me?
Can you tell us what's on the menu?
So I did an Asian buffet for the lunch on the Friday. And then the dinner is a stuffed with cheese, I think, chicken,
Perfect.
something.
I picked that.
With the mixed salad. And then, oh, the dessert, I probably picked something chocolate. I think it was chocolate, something mousse cake, something like that. And then the brunch for the next morning is like your, you know, full on carbs and fat. Again, with lots of vegetarian options. So should be fun. It's in Toronto at the Pan Pacific Hotel. So yeah, enjoy. I had to plug it. We got a few seats to sell, so hope you can join us.
Sounds delicious.
Yes, yes, yes. Good stuff. Thank you, Marian, for being with me. It was the Marianne show, so I hope you enjoyed it, everyone. Take care. I'm going to stop recording.